We're going to go ahead and get started. First, I wanted to thank Keith for coming in and thank all you guys for coming. I know it's hard to get out of our offices, and even worse if you have to do so by coming down I-4. So we truly appreciate you being here. For those of you that don't know me, I think there's not many, I'm Myra. In the back I have Patty and Kat. I know several of you have worked with them throughout the years, so thank you ladies for coming and getting everything set up and ordering breakfast and stuff. For those of you that don't know AAG, I'll run through an overview of who we are and kind of what we do real quick. So this just says we're amazing. Mainly it's because of our team, for sure. You know, Luann would be here, but it's really early for her. So, and she's a good distance away. I know that a lot of you work with her, and then again, Patty and Kat. What we do is work with companies on your employee benefits. We're very proactive on that kind of stuff. Can offer management training. Most everybody's at least been on a conference call or had Keith in your office before to help us with employee issues. So, you know, a lot of our focus is on planning and prevention. And then you have access to myself 24/7. I've taken plenty of calls on nights and weekends, which is also a good thing to have Keith, so I can bug him at the same time. So we really appreciate our partnership there. Our annual I9 audit's coming up in June. For those that are interested, Patty will be on the road doing that. You know, as most of you know, we come by on a monthly basis, and we always have a topic we're covering. This year, a lot of our focus was on retention. May, we're actually going to dial in pretty heavily on wage and hour, and then again, June will be that I9 audit. We keep our clients for a really long time because we try to do hand-holding. So if you're not a client, ask your neighbors what they think of our services. And without any further ado, because we've got a lot to cover, I'll go ahead and let Keith know. For those of you that need SHRM credit, Kat's got a flyer. We can put these on the back table there, so that'll give you your IDs to go ahead and get your continuing education credit. All right, Keith.
All right.
Thanks.
Thank you. Good morning, everybody. As if I need to speak into this microphone, and usually I don't. Usually I'm a fairly boisterous guy, as many of you know. It is a pleasure to be here. I thank all of you for being here today. Very frequently I will be fielding a call from one of you, and one of my first questions is, how are you doing today? And the answer is inevitably, Keith, if I'm on the phone with you, I am not having a good day. Today's a different story. Nobody hopefully has any pressing fires that need to be put out. If you do, we can talk about this afterward. We're here today, though, for the employment law update for 2019. We will be covering a number of topics today. Possibly the first topic is what hooked you in. I give full credit to Myra for coming up with the title of this one, Up in Smoke, Medical Marijuana in the Workplace. We've actually had some very recent developments, so if you've heard this topic before, the presentation that we'll go over today is probably a bit different from what you've heard in the past. We'll also talk about accommodations in the workplace. I personally, and I would think that Myra would probably agree with this, have seen more accommodation request issues in the last 6 months than I had seen in the previous 2 or 3 years. And some of the accommodations or requested accommodations might sound kind of wacky on their face, but believe it or not, the EEOC is taking the position that you at least need to consider those. So we'll talk about those different types of accommodation requests. If you attended this very update 2 years ago, you probably remember that a couple of the topics we discussed were the new overtime rules and how we were going to have to change everything, as well as the new EEO1 reports where we would have to include all sorts of pay data. I might sound like a broken record for those that were here 2 years ago, but those are back in the news again. We'll go over the who, what, when, where, why, and how, and what we need to do to be ready for some upcoming changes. As everybody knows, I cannot get through one of these presentations without using the words protected concerted activity. For those that don't know what protected concerted activity is, don't worry, I'll give my patented 30-second primer on that. But in a nutshell, protected concerted activity is protected by the National Labor Relations Act. We will be discussing how the current presidential administration's NLRB, National Labor Relations Board, has been unwinding some of the rulings that came out of the President Obama era National Labor Relations Board. And then finally, we'll wrap up with a segment on what's going on in the court system, what we've seen out of the Supreme Court, and what we can expect to see coming down the pike soon. So without further ado, let me get started. As you know, if you've attended one of these before, I love fielding questions. You do not have to wait until the end to raise your hand and ask a question. Don't be shy. We're a pretty intimate group here, and many of us know each other. So feel free to ask as we go along. Let me tee this up by going over a brief chronology of how we got to where we are with respect to medical marijuana laws and how they impact the workplace. Back in 1996, California became the first state to legalize medical marijuana. From 1998 through 2012, there were 17 additional states that legalized medical marijuana. In 2012, the reason I make a big point on this date is that's when we start to see states legalizing not only medical marijuana, but recreational marijuana as well. Colorado and Washington were the first two states. This is probably recent enough that most of us remember this as it was going on. And certainly recent enough is in 2016, Florida voters voted to amend the Florida Constitution to permit medical marijuana. That bill had been on the table in 2012 during that election. It did not get enough votes to pass in 2016. It did. In 2017, the Florida legislature, in response to this amendment, while under Governor Rick Scott, banned smoking medical marijuana. So you could take medical marijuana, but it had to be in some form other than smoking it. Just last month, you might remember Governor DeSantis, new sheriff in town, new Florida legislature, overturned that ban on smoking medical marijuana. So now persons with prescriptions are entitled to use it in smokable form. Where are we today? Well, today, all states except for Idaho, South Dakota, and Nebraska have legalized some form of marijuana use, either recreationally, medically, or medically with some sorts of restrictions like the THC content has to be below a certain threshold level. Why am I telling you about Idaho, South Carolina, or South Dakota and Nebraska? Some of you likely have nationwide operations, and as we'll see in a few minutes, you should be very cognizant of what the differences in state laws are if you have multi-state operations. Now, just because the states make marijuana use legal does not mean that the feds see it that way. Technically, marijuana is still a controlled substance, a Schedule I drug. Schedule I means that there is no medical use for it. It's highly potential, or there's a high potential for it to be addictive. And if you're a Schedule I drug, there is no way that you are legally entitled to be in possession of or to use it under federal law. The DEA, a federal agency, within the last couple of years has even reviewed whether or not marijuana should stay a Schedule I drug or whether it should move to Schedule II, meaning it's a prescribable form of medication. They declined to do so. So in the eyes, technically, of the federal government, marijuana is still a Schedule I illegal substance. Now, I will also tell you this. Both President Obama and President Trump have indicated that they had no opposition to the medical use of marijuana, notwithstanding what the DEA has said. And there are very few federal enforcement dollars going toward busting people who are taking marijuana lawfully under state law. It's really not happening. Not to say that that might not change, not to say that might not turn on the dime, but that's the reality of the atmosphere that we are working with. So here's the million-dollar question. Hopefully it's not $1 million, but if you find yourself on the end of an EEOC charge, that might be the first thing that goes in your mind is, oh my God, how much is this going to cost? Do I have to allow employees to use marijuana if they have a prescription for medical marijuana? No, I see some no's, I see some, I don't know. Well, that's why we're here, right, is to talk about whether you need to let them do it or not. Well, your first thought is probably, well, Keith, is this a reasonable accommodation under the Americans with Disabilities Act? We're throwing out the words medical here. Basically, a request to use medical marijuana is a request for an exception to your drug-free workplace policy, which I think just about everybody here has in one form or another. I'll wait till the train passes by. Let's count to see if we have more trains pass by than the number of times Keith Hammond says protected concerted activities. My money is on me, by the way. The answer is this. Under the ADA, which is a federal law, employers are not required to break other federal laws to accommodate employees, and I should say qualified employees with disabilities who need reasonable accommodations to perform the essential functions of their job. In the early days of medical marijuana bills being passed, nationwide in various states, courts routinely sided with the employer in saying employers don't have to accommodate employees who use medical marijuana by making exceptions to their drug-free workplace policies, even when the employee doesn't show up under the influence. But let's say they go out for a drug test for whatever reason. Maybe they got into an accident at work. You send them out for the post-accident test. It comes back positive for cannabinoids, and you let them go because that's what you do under your drug-free workplace policy. Employee sues you, you go to court. The courts generally, at first, sided with the employer. You don't have to accommodate that. But here's where the presentation spins off from what you have heard previously about medical marijuana in the workplace. Employees are starting to win these lawsuits. The rationale that the courts have in siding with the employees is that, yeah, we know there's a federal law, the Americans with Disabilities Act, and we know that there's a federal law that makes marijuana a Schedule I substance, the Controlled Substance Act. But you know what? In addition to federal laws, we, the judges, also need to be mindful of state laws. And our state law here makes medical marijuana use, or in some instances, recreational marijuana use, legal. And we also have a state law that's kind of like the ADA, in that the state law prohibits discrimination on the basis of disability. Failing to provide a reasonable accommodation is a form of disability discrimination. And unlike federal law, where the requested accommodation is to use an illegal substance, under state law, the requested accommodation is to use the same substance, which happens to be legal under state law. Therefore, the courts who employ this rationale come to the conclusion, you have to provide that reasonable accommodation. Unless you can show it would be an undue hardship, unless you can show maybe this person's in a safety-sensitive position where having marijuana in your system could lead to harm to themselves or to others. The first case that really went over this, the Barbuto case, came out of Massachusetts, where the court said that, hey, an exception to the employer's drug policy to permit off-site marijuana use may be a reasonable accommodation where the employee's physician determines that marijuana is the most effective treatment for the employee's disability and that any alternative medication permitted by the employer's drug policy would be less effective. Yes?
We went to a training on this a while ago, and they were talking about the difference between getting a prescription and having a medical marijuana card. And because it's not a prescription drug yet, what's the difference there?
Yeah, so the question is, what's the difference between having a prescription for medical marijuana or having a medical marijuana card? For purposes of this discussion, for the employment law discussion, I would treat those two terms synonymously. Each state has their own verbiage that's within their state laws to who's permitted to access medical marijuana. Many states requires that you acquire it from a dispensary, Florida being one of them. You can't go to Johnny on the street corner in the trench coat and, ask him for some medical marijuana and be in compliance there. You have to go to a licensed dispensary. And at the dispensary, you need to show either a prescription or the card. For our purposes, think of them as the same thing. Yes?
We just had this come up. What about the rub that they're using now? Oil.
Yeah.
We just had this problem because a lot of it can be purchased over the counter. A lot of people who are going to doctors, the doctors are saying, you won't test positive for drug screens. Well, guess what? We just had somebody tell
Random
a
test.
random drug.
Right.
So how are they looking at that CBD oil?
So the question has to do with, well, what if they are taking some sort of over-the-counter CBD oil or something that they don't even need a card for or a prescription for? And actually, let me defer on that because we're going to talk about it in the next slide or so. But the punchline to the joke, I suppose, is, first of all, if it's not for medical use, we don't have to worry about making accommodations. If this isn't necessary to enable somebody to perform the essential functions of their job, we don't have to worry about it. We can have our drug-free workplace policy and prohibit the use of any sort of cannabinoids in the workplace. It's where we have a legitimate, and I'm not going to get into the politics of calling this legitimate or not, but a legitimate doctor saying that the most effective treatment for this person's condition is the use of medical marijuana. Interestingly enough, many states, but not the ones you might think of, are beginning to write employment protections into their marijuana legislation statutes. In other words, saying, hey, as an employee, you're allowed to use this off the job, not on the job, as long as you're not under the influence of it when you come into work. Those states are Arizona, Alaska, Connecticut, Delaware, Illinois, Maine, Minnesota, New York, Pennsylvania, West Virginia. Other states have laws on the other end of the spectrum. They specifically allow employers to have a zero tolerance policy. And they even prohibit employees from bringing lawsuits in the first place if their claim is based on, hey, I didn't get the chance to smoke medical marijuana because of my company's drug-free workplace policy. Ohio is the big one. More recently is New Mexico, North Dakota, and Washington State. Interesting, since Washington was one of those states that legalized recreational marijuana. And then many states' medical marijuana laws either specify that they don't require accommodations or they're silent on it. So in other words, the statute does not say you have to make an accommodation, it just doesn't say anything. California is one of those states. Surprise, surprise, you would think that California, being the most pro-employee state that's out there, would likely have those protections in place like the Arizonas and Alaskas of the world. Florida is one of these states as well. There is nothing in the Florida constitutional amendment or in the statute that requires employers to make reasonable accommodations. But wait, there's more. In one of those states that has legislation, medical marijuana legislation, that specifically says nothing in this statute shall be construed to require an employer to accommodate an employee's use of medical marijuana, the New Jersey court nonetheless found that, hey, even though the medical marijuana law doesn't require you to make the accommodation, our anti-discrimination law, which cleverly enough is called in New Jersey the law against discrimination, might require you to make that very accommodation. And the court in this case, which was just decided last month, sent the case back down to the lower court to determine whether or not allowing an employee to use medical marijuana would be a reasonable accommodation under their state's anti-discrimination law. So where does that leave us as Florida employers? Even if you don't have multiple state operations, you're just operating in Florida, well, our medical marijuana statute does not require that employers make reasonable accommodations by allowing them to use medical marijuana. But we have a law here in Florida that is virtually identical, for purposes of our discussion today, to the New Jersey law against discrimination. It prohibits discrimination on the basis of disability. And the New Jersey court said that's enough to require an accommodation, and that accommodation might be allowing somebody to use medical marijuana. No Florida court, at least as of yesterday, I updated my research before coming and speaking today, but as of yesterday, no Florida court had decided this issue. I'm not even aware of a pending case here in Florida, which would not be out of the ordinary, because even if an employee had gotten fired on day one of medical marijuana being permitted, it likely still would not be in the court system yet. They'd have to file a charge of discrimination with either the Equal Employment Opportunity Commission or the Florida Commission on Human Relations or some other local investigatory agency. I mean, it can take 2 years to get a determination from those entities. Then you have to file the lawsuit. It takes a couple of years to get to trial. So we're still, in my humble opinion, a year or two at a minimum away from seeing a Florida court, rule on this particular issue. So, if I'm a Florida employer, what am I supposed to do? Well, here's the spectrum of options that I would suggest to you. Number one is maintain the status quo. You know, if you maintain the status quo, I'm assuming your status quo would be we prohibit the use of marijuana or being under the influence of marijuana or failing a drug test by finding cannabinoids in your system. If we do that, we fire you. If you wish to maintain that status quo, my legal advice to you would be that's fine. The risk if you do that is you may end up being that case where an employee is arguing, hey, I'm being discriminated against on the basis of my disability. How would I predict a Florida court would go in deciding that particular issue? I throw my hands up in the air. I think it probably depends on maybe the judge, maybe the area of the state in which the case is brought. You know, some pockets are more liberal, more pro-employee than others. I would be willing to bet there's probably a special interest advocacy group that is waiting for the right case, you know, the right circumstances and the right location in order to bring this. But that's one end of the spectrum. Status quo, maybe not a bad idea to give Myra a call or give Keith a call before firing somebody for this reason, just to say, hey, I was at that seminar in 2019. Has there been any change in the law? Has any Florida court addressed this yet? Just to make sure you're not blatantly violating any decision that's out there. The other option, and by the way, I would say that of the clients that I have spoken to, the majority of them choose to stay with the status quo. There is a smaller minority of clients that has chosen to go the other way, which is the other end of the spectrum, is to reevaluate your drug-free workplace policy and to, when appropriate, permit the use of marijuana under certain circumstances, such as it has to be medical in the sense that there's either a prescription or a card or whatever, and that the employee not be under the influence while at work and not use it while at work. And interestingly enough, most of the clients that I've seen who choose this path choose it because they have a longtime employee who in 2016 or 2017 stepped forward and say, hey, just so you know, I have the card or the prescription for medical marijuana, and the employer doesn't want to get rid of that employee. They're such a good employee, they know they're not going to replace them. Is the person's use of the medical marijuana detrimental to their performance at work? Probably not. They've probably been doing it without the medical marijuana prescription for the last 20 years, right? So they decide, well, here's what we're going to do. We're going to shift gears, and from here on out, as long as you meet these criteria, we're not going to fire you for testing positive for marijuana. Now, be mindful, if that's the route you choose to go, you can't make ad hoc decisions like letting Patty stay, but Kat, you're fired if you test positive. It has to be across the board because you don't want to be accused of discrimination on any other basis.
So that actually, we have different types of employees. So for some, the use of at work would affect the safety of others, say engineers,
Yep.
architects. Our salespeople, it would not. So we cannot treat them separately for reasonable accommodations.
So,
We wouldn't have to do it at work anyhow.
well, this is a great illustration because one of the cases, just spoiler alert, I'll go over the case now rather than at the end of the presentation, has to do with when you're evaluating a discrimination case, who is the pool of people that you need to compare the plaintiff to, the employee to. And very recently, the 11th Circuit, which is the Federal Circuit Court of Appeals over Florida, as well as Georgia and Alabama, ruled that the universe of people you're comparing them to has to be similarly situated in virtually all respects. Usually that means they're doing the same job, they're reporting to the same supervisor, they have the same duties, etc. The question, by the way, if it didn't get recorded, was what if I have distinct groups in the workplace? Some of them would pose safety hazards if we were to allow them to use marijuana, whereas others, it doesn't matter. There's not going to be a safety issue there. Could you distinguish among them on that basis? My answer would be, I suppose there's some risk in doing that, but to me it sounds okay. And what I would be sure to do is make clear at the outset that this is the group that is not safety sensitive, this is the group that is, rather than waiting to approve one request and deny another request and then come up with the reason why. So if that's the route you're going to go, what I would recommend doing is change your policy ahead of time now so that it's clear on a going forward basis which universe of employees might be given an exception to the rule, an accommodation might be made for them versus which ones the requested accommodation would pose an undue hardship or risk of harm to themselves or others.
What about just removing it from the panel? Like if on Rebecca's, you had the salespeople, when they take it, you test for everything except marijuana and then everybody else.
So the question is, should you just remove it from the panel? Whether it's a divided workplace where some of the employees we're going to turn the blind eye to, or whether you decide, hey, workplace-wide, there aren't any safety-sensitive positions. Could we just remove cannabinoids from the panel? If that's the direction you're going to go, I don't see a reason why not to do that. With the following caveat. Be mindful that if this end of the spectrum appeals to you, you will need to consider whether or not your drug-free workplace policy was implemented pursuant to the Florida Drug-Free Workplace Act. In Florida, as a reminder, you don't have to have a drug-free workplace if you don't want to. But if you have a drug-free workplace and you have a certain type of policy in place that has a number of requirements that are listed in the statute, you might get a discount on your workers' comp premiums. And removing cannabinoids from your panel or permitting employees to fail the drug test for cannabinoids and not be terminated may end up eliminating your ability to get that discount on the workers' comp premiums. And sometimes that discount is pretty hefty. I think it maxes out at 10%. Myra, tell me if I'm wrong, 5%. 5%, but if you have a large workforce, that 5% could be a very significant amount of money. So if you're in that boat, my recommendation is I might stick with the status quo at this point and continue to get the premiums until we have to address whether or not somebody comes forward with a request for an accommodation.
So this may be just because I don't know the answer. So when we say you can use it let's say we don't, you can use it outside of work, but we're saying you cannot use it at work. Is there a test that differentiates, because with alcohol it's fairly easy, but with marijuana it stays in your system. So how would you go about even knowing and then being able to discipline for, and they say, well, it was 7 days ago?
Yeah, I think that there are two competing issues going on there. And just to repeat the question, marijuana stays in the system longer than something like alcohol. Alcohol use in the workplace might be more obvious. What if you send somebody out for a drug test, they test positive for marijuana, but say, listen, I did that 7 days ago on a weekend, or I was out on medical leave and I smoked it at the beginning of medical leave, and I was certainly not under the influence of it 7 days later when I came back. So the two competing things that are going on here is, number one, when are you sending out, or when are you able to send employees out for a drug test? What comes immediately to my mind is the most frequent type of test for alcohol, this is my perception, maybe it's not statistically accurate, would be reasonable suspicion. Somebody comes in and you smell it on them, right? Or, they have the signs of being under the influence, you send them out for the drug test. In some instances, marijuana use would be similar. You might smell it on the person, you might see them with red eyes, they might be blaring Bob Marley, I don't know, or Jimmy Buffett, hey, whatever. And so you're like, hey, I think this person might be under the influence of marijuana. Let's send them out for a test at this point. The other one, though, the other issue that you raised is, what if they're being sent out for a completely different reason? Post-accident comes to mind. The accident wasn't necessarily caused by being under the influence, but most drug-free workplace policies, whether compliant with the statute or not, have post-accident testing. And that comes back. Or maybe you even have random testing in your workplace where the drug testing administration company calls you up on a Monday and says, these 3 people won the lottery, send them down here to provide a sample. And I suppose at that point, there are things that you could do. These are considerations to have. What was the concentration that was in their sample? And is the employee's story that they're telling you consistent with what the drug test revealed? So if the concentration was so high that there's no way 7 days could have gone by because they would have had to smoke 2.5 truckloads of marijuana in order for the concentration level to be what it is 7 days later, then I would say let's let that person go. If it's plausible, and again, remember, we're discussing this in the context of making reasonable accommodations for disabilities, not just generally allowing people to smoke marijuana in the workplace, then I would say it's warranted to do an individualized assessment to determine whether or not you should grant the accommodation of not firing the person for violating the drug policy. All right.
Mine just told me that the labs are, if the employee tests positive and the employee shows their card or prescription or whatever, that the labs are just saying, oh, then they are fine, and not letting employers know.
Gotcha. And maybe it's important for you to know what the labs are doing. You might want to ask your labs what's your position on testing for the cannabinoids.
They will tell us what they have in the card and what people let us know.
Okay, perfect.
Yep. Any other questions on medical marijuana? Hearing none, but continuing the trend of accommodations in the workplace, I mentioned earlier that Myra and I have both fielded far more issues pertaining to requests for accommodations, even those that don't pertain to the Americans with Disabilities Act. The ADA and the state law equivalent, Florida Civil Rights Act, are not the only laws that require employers to make accommodations in certain circumstances. For example, Title VII, which is the law that prohibits discrimination on the basis of race, color, religion, sex, national origin, might require you as the employer to make religion-based accommodations for employees. The Fair Labor Standards Act, the overtime and minimum wage law, requires covered employers to provide breaks to employees for breastfeeding or breast pumping. And then, of course, going back to our old friends, the Americans with Disabilities Act and the Florida Civil Rights Act, we have disability-related accommodations. And I want to get everybody up to speed as to what the EEOC, the Equal Employment Opportunity Commission's position is on certain accommodations. So here's my 2-second primer on accommodations in the workplace. I find that managers in general, not necessarily human resources professionals, but your managers and supervisors, the ones who are actually, on the line with the employees or their first level of management down on the floor, struggle with the concept of accommodations and unknowingly deny accommodations that might be considered reasonable. Here's why they struggle with it. They've probably been trained that the very basic concept of discrimination is you have to treat people the same. You can't treat one group of people less favorably than another. You can't treat this group more favorably than that group when it's based on a protected class. So when somebody comes to them and says, hey, listen, I have anxiety. I need to bring my chihuahua into work to make me feel comfortable. And the supervisor says, yeah, no, nobody gets to bring their pets into work. So sad, too bad. And now the EEOC is knocking on our door. Why is that? It's because accommodation law runs contrary to logic when it comes to discrimination. Accommodations, by definition, mean that you're treating somebody more favorably. You're treating somebody differently because of their disability or perhaps because of their religion. And supervisors are reluctant to want to treat people differently, maybe rightfully so, but it's important that they know and that all of us know that failure to provide a reasonable accommodation, other than when the requested accommodation would be an undue hardship, amounts to discrimination on the basis of that protected category. The common issues that I have with religion-based requests for accommodation are up here, so let's walk through each one of these, and if you have questions or if this has happened in your workplace and you came to a different result, feel free to raise your hand. An applicant fails to disclose the need for time off for worship services until after you've already extended the job and they start working for you. What's your response? Well, I never would have hired you if I'd known this, right? Wrong, 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 wrong. It does not matter. The employee does not have to disclose that they have a need to have certain time off for religious services before they apply for the job. They're perfectly free on day one to come to you and say, by the way, I need every Saturday off, I need every Sunday off because I have worship services that last all day. You must accommodate a bona fide, sincerely held religious belief, as long as it's not an undue hardship. An undue hardship, however, under religious accommodation is different than it is under disability accommodation. If you've ever been in this position before where you've had to ask Myra or me, hey, I have a person with a disability, I operate a supermarket and the cashier wants a stool to sit on because he or she is limited to standing no more than 5 minutes at a time. Do I have to do this? And our answer is, yeah, you got to find the chair, even though it costs you $10, get it out there and accommodate the person. In the context of religious discrimination, almost any cost at all to the employer would be considered an undue hardship. Now, the $10 example is probably a bad illustration because if you have to spend $10, the court is going to make you do it. But if you had to spend $10,000, you probably would not. If you had to force one particular employee to have to work every single Sunday in lieu of this person who wants to take the time off for religious services, that might be an undue hardship. But if you have a universe of 4 or 10 or 12 who can pick up one Saturday every turn in the rotation, that would not be considered an undue hardship. That's something that you would have to allow the employee to do.
We actually had an employee at one place I worked, we hired them just to work on weekends, and they came in and said, by the way, I cannot work on Saturday due to my religious beliefs. It's like, that's 1 out of the 2 days you were going to work every week. So
Yep.
we called our attorney and he said, no.
So
They applied for a Saturday and Sunday job and it made no sense.
for purposes of the recording, here's the scenario. An employee applies for a Saturday and Sunday job, takes the position, and then says, by the way, I can't work one of those days out of the week. And the company attorney says, company attorney says, no, you don't have to do that. And I agree wholeheartedly with that legal advice, but let me make a suggestion here as to how to avoid that in the first place. I said the employee has no duty to just voluntarily disclose whether they can do the job. But you as the employer certainly can ask them whether or not they can work the schedule that's required of the position. And if not, is there an accommodation that they would like to request so you can evaluate it. So that way you know ahead of time. And I'm not saying that you have the green light to terminate somebody on day one when during the interview they said, no, I have no problems, I don't need an accommodation, and then they say all of a sudden that I do. I mean, there might be some other mitigating circumstance where you wouldn't terminate there, but it certainly helps to have that in your quiver, so to speak. The next common religion-based accommodation request would be a request to either take breaks or for some physical space in the workplace, or both, so that the employee can pray at certain times of the day or at certain hours of the day. And this one is tricky, or can be tricky. You know, if you have a vacant office that the employee can slip off to for 5 minutes at a time, that's a reasonable accommodation. There's no way that you're going to prevail in arguing that's an undue hardship for you. Even when, the other employees start to complain, why is so-and-so always sneaking into that office? I think he or she is taking a nap. Look, you gotta do this. You gotta provide that accommodation. It gets trickier when there isn't any available space. And then what do you do? Well, under the law, you might have to consider allowing them to drive home. I mean, this was a real life example. Drive home to tend to your daily prayers and get back to work within a certain amount of time. Well, if they're going to be gone for more than 30 minutes, is that paid or unpaid? Well, generally, you can probably not pay them for that time. Generally speaking, when providing accommodations, you would follow your normal break policies. If it's a meal period, uninterrupted 30 minutes, it's unpaid. If it's a 5-minute break, you stay on the clock. There's some gray area between 20 minutes and 30 minutes where you might be able to get away with not paying them. But essentially, that's what it is. Don't end the analysis at, we don't have a free office, so we don't have to provide that accommodation. I'm not saying that you do need to allow the person to miss an hour of work at a time, 3 hours a day. That's probably not reasonable. But if the employee happens to live down the block from the office and can run home and back within 10 minutes, that probably is a reasonable accommodation. One of the tricky things about accommodation law is that there are very few bright line examples of what is required and what you would not be required to do. The EEOC takes the position that every request for an accommodation has to be evaluated on an individual case-by-case basis. And if you're inclined to deny the requested accommodation, you need to be able to explain why it would be an undue hardship. Another one that many people don't even think of until it's already upon them is employers frequently have grooming or dress code policies that say things like, oh, I don't know, men can't have their hair down beyond their collar. And an employee comes to you and says, hey, listen, I'm Rastafarian, I wear dreadlocks, I am entitled to have an exception to your grooming policy. And the answer is, in many instances, if not most instances, the employee is going to end up being correct on that. And you would have to make that accommodation. I can envision certain examples where you would not, where there would be some sort of safety hazard because they're leaning over heavy machinery that their hair could get caught in and cause an industrial accident. Maybe even an illustration where the employee works for one of the theme parks as a costumed character and the appearance would take them out of costume such that they wouldn't be believable. But being the teller at the ticket window at the theme park, you would probably need to accommodate their request for an exception to the dress code, as long as it is based on a sincerely held religious belief. How about when you have an employee who turns out to be super religious, working side by side with the atheist or agnostic who wants absolutely nothing to do with their constant, prayer slogans hanging up or invitations to go to their church, mosque, or synagogue. That, by the way, is called proselytizing. The invitations to join for worship services or let me spread the good word to you. The non-religious employee comes to you and complains, I don't want any part of this. What are each side's rights? Let me start with the premise that Title VII prohibits discrimination based on religion. That includes protection against discrimination for not being religious at all. Everybody is protected under this particular category, religion, whether you're atheist, agnostic, or very religious, or moderately religious. So both sides have rights here. What do you tell the employees, the complaining one and the person who's doing the proselytizing? Well, the first time the super religious employee goes and proselytizes, does that amount to unlawful harassment? The answer is no. Does the non-religious employee have the right to tell the religious person, thanks but no thanks, I'm really not interested, I'd rather we not have these discussions again? Absolutely. Now, if that message is sent in a different tone, that could be construed as hostile. But even still, stray remarks, one-off comments generally don't rise to the level of unlawful harassment. Hopefully this issue is coming to you by this point and not after a 5-year period of the proselytizer doing the proselytizing and the non-religious employee saying, stop preaching to me, I don't want to hear about it, you religious SOB, or something along those lines. So assume for the sake of argument, this has just arisen. Can you now go to the employee doing the proselytizing and say, hey, listen, so-and-so has indicated they're not interested in having these discussions, we would like to ask you to refrain from having them at work. And even if you continue to do so, we will implement discipline against you. The answer is yes. The non-religious person has the right to work in a harassment-free work environment. And continuing to proselytize towards somebody who is known to be agnostic, atheist, non-religious, and not interested could amount to workplace harassment, a hostile work environment. You have the obligation to ensure that all your employees work in a harassment-free environment. You go to the religious employee, you say, listen, you're free to do whatever you'd like to do, except proselytize toward people who don't want to be proselytized towards. That is okay. That's the way to handle that situation. What if you question the sincerity of somebody's religious belief? I need to bring in my Chihuahua because I belong to the Church of the Small Dogs and it's part of our worship. The conclusion may well be no. But here's the path to get there. If you question whether an employee has a sincere religious belief, if you have a reasonable basis, you can make a very limited inquiry into the belief or the practice at issue, whether it's religious, whether it's sincerely held, and whether the belief requires you to make an accommodation. Just because I belong to the Church of the Small Dogs doesn't mean that one of the Church of the Small Dogs practices is to bring the Chihuahua into the workplace. Maybe we just have calendars of our small dogs and that's good enough, right? So if it's not a requirement under the religious belief to bring in the dog, you don't have to allow that. Here's the rub, though. You can't require the employee to provide this information in any specific form. You can't say, I need a note from the minister of the Church of Small Dogs in order for me to consider your accommodation request. Many times it's enough that the employee just gives you their own verbal account that, yes, this is required. Or even another member of said religious group might tell you, oh, yes, this is legit, and yes, John certainly has this particular religious belief. Before I shift to disability, any questions on religion-based accommodations in the workplace? Hearing none other than everybody's probably fearing going back and wondering what's going to come up the next time somebody makes a religion-based accommodation. We turn to our old friend, the ADA. The Americans with Disabilities Act has regulations that give us a list of potential types of accommodations we at least need to consider whenever somebody says, hey, I have a medical or physical condition. Here's the accommodation that I need in order to be able to do my job. You must consider whether it's possible to make your existing facilities accessible. Somebody says, hey, I'm in a wheelchair. I can't work on the second floor because we only have stairs here in the office. Can I have a first floor office? You would at least need to consider that. You might need to consider restructuring their job. If there's one particular function that the employee can't perform, you might have to evaluate whether you can give that to another employee. If they tell you, I can't work full time, I can only work 6 hours a day rather than 8, your answer is not, sorry, this is a full-time position. Your answer has to be, well, let me evaluate whether or not there's a way that we can make that work. A modified or part-time. You may be obligated to acquire or modify equipment. I gave you the example of the stool for the cashier to sit on. It could be a much larger piece of equipment if you are a affluent company with high revenues. The bar is certainly higher for you as to what qualifies as a reasonable accommodation as opposed to an undue hardship. You might have to change your employment tests. You might have to change your training materials. You might have to modify your policies or permit employees to have an exception to your policy. That's where the entire conversation about medical marijuana comes from. You're making an exception to your policy, your drug testing policy. You might have to provide interpreters or readers. You might have to reassign an employee to a vacant position that they are capable of performing. The biggest issue that I see when it comes to disability-related accommodations has to do with leaves of absence. And just last week, I got a call from a client who tells me, Keith, we probably should have called you earlier than that, but we've got about 3 employees who have been out for the last 6 months and they're still on the insurance. They're not paying their portion of the premiums. It's costing us money. What do? We have no idea when they're coming back. They've exhausted their FMLA. Can you terminate somebody once they've exhausted their FMLA on week 12 plus 1 day? Not without first having a conversation with them. You may be able to do so, but the EEOC takes the position that having a policy where you automatically terminate somebody if they're not able to return on a specific date amounts to discrimination, unless you evaluate whether affording them additional leave would be reasonable or an undue hardship. I'll give you 2 illustrations as to what's reasonable and what is an undue hardship. Employee exhausts their FMLA leave, or if you're not an FMLA-covered employer, they've simply exhausted whatever PTO they have, whatever sick time. They're not able to come back. Your question to them should be, hey, how are you doing? Do you have an expected return date as of right now? Their answer may lead you to inquire further. The way that you would inquire further, by the way, is to give the employee a letter to take to their doctor with various questions about the employee's severity of the condition, whether there's any accommodation other than a leave of absence that would eventually enable them to perform the essential functions of their job, and whether the employee is capable now or in the foreseeable future of returning from leave, and if known, when will they be able to come back. Now, by the way, I know I've worked on those types of letters with a few of you that are here, but that's what you're supposed to do. Do not reach out to the doctor directly. You're not entitled to do that. By the way, maintain a separate form, separate and apart from the personnel file that has this letter and any medical stuff. We all know that those are the rules, right? If the doctor responds that so-and-so needs to have another week off of work and then they'll be able to come back, you got to give them the week off. That would be a reasonable accommodation. I can't think of any employer who's covered by the ADA, 15 or more employees, who would not be able to give an employee an unpaid week off if the employee can return at the end of the week. If the doctor says, employee has a very bad condition, it's unknown whether they will ever be able to return, that's not a reasonable accommodation to allow them to continue to stay on leave. At that point, you can tell them, listen, sorry, we hope that you get better, but we have to administratively terminate your employment now. You'll get a COBRA letter, yada, yada, yada. What if the doctor says, the employee eventually will be able to come back, but I don't know when. The employee needs an indefinite leave of absence. Again, not reasonable. That's an undue hardship. The EEOC's guidelines even tell us that they will not side with an employee in that particular circumstance. What I find to be the tricky middle ground is what happens when the doctor note says the person needs a week and then a week goes by, can't come back. Another doctor's note, employee needs another week. Week goes by, can't come back. Third week now, you're in. Fourth week, when is enough enough? Well, at some point, what I would recommend, and granted this is not a guarantee that you would end up prevailing in the EEOC charge that gets filed, is to write to the doctor to say, listen, doctor, we've written to you 4 times in the past. Each time you said that the employee just needs 1 more week before they can return to work. Each time at the end of the week, the employee says, I'm not able to return, and you tell me there's 1 more week. Can you state with reasonable medical certainty when the employee is going to be able to come back to work? And hopefully at that point, the doctor will either say, no, I really have no idea, at which point additional leave is no longer a reasonable accommodation, or the doctor will say, yeah, with reasonable medical certainty, he only needs 1 more week. All right, let 1 more week pass, and then at that point when the employee says, I still can't come back, now I think you're somewhat justified in saying, I can't rely on the doctor who now has told me 6 times the employee just needs 1 more week. You know, we cannot continue to afford additional weeks, 1 week at a time. This is no longer reasonable. Obviously, the more time that has passed, the more times you've granted 1 more week, I think the safer ground you're on taking that position. I wouldn't do it after, the first time, the second time, even the third time. At the 4th time, you might be able to convince me to say, it's a lower risk than it was. The risk will always be there. There will always be some risk, but it's at least a little bit lower now. I saw a question.
What happens if you create that kind of a letter and you send it to the doctor, but doctors don't respond back?
So if you don't receive a response back, and granted you should give the employee a couple of chances after the initial deadline to get that response back, you tell the employee, listen, we tried to obtain further information so we could evaluate your request for an accommodation, but we've not gotten a response, so we can't evaluate it. We can't grant you that accommodation. Now, to be safe rather than sorry, like I said, give them a couple of chances, maybe even suggest to them you might want to go see another provider who can answer these questions for us. It may well be, however, not that I'm accusing employees of doing this, that the employee sees what the doctor is going to say and they intercept the letter and don't provide it to you. Because many times that's how the doctors will get the letter back to you, is by giving it back to the employee for you to receive from them.
Put in our letter, it has to come directly to HR through fax or email.
That's okay to do, but be mindful that you should not have that direct communication with them. It's okay to receive directly from them, but I would not reach out if you have follow-up questions. If you have follow-up questions, do another letter.
And we give it to the employee, give it to
Yeah.
the doctor, and we ask them to send it directly to us.
Yeah, that's okay. By the way, for the recording, the scenario is we give the letter to the employee, we ask the doctor to send the response directly back to us rather than through the employee. That's okay to do. Just don't reach back out to the doctor directly. All right, another issue, frequent or extended bathroom breaks. This has got to be one of the most kind of potentially embarrassing topics that comes up, but I see it frequently. So-and-so comes to you, hey, I have Crohn's disease, you'll notice that I'm in the bathroom quite a bit during the day, that's why. Coworker says, hey, I think John is, on Facebook in the bathroom for 20 minutes a day. Are you going to conduct an investigation into this allegation? Probably not. Aside from maybe asking John, hey, we just want to make sure that your need to use the restroom is due to the Crohn's disease. And when John says yes, you need to continue to allow John to do that. Here's what makes this so tricky. You're not allowed to tell the complaining coworker that John has a disability. So how do you deal with the complaining coworker? There's no good answer to that. I wish I had one. The best that I can come up with is to tell the employee, listen, we'll monitor and we'll address things that are appropriate, but at some point you probably want to slip in some anti-discrimination, anti-harassment training for employees so they know that there may be accommodations your employer is providing to coworkers and they can't tell you about it. Don't ask. We can't tell you about it anyway. You might think that this is not fair, but there may be some legitimate reason that it's happening. I always use the example in training like that of the Publix cashier using the stool because everybody has seen a cashier using a stool. And I'll tell them, if you work at Publix, your manager is not telling you why so-and-so gets to use that stool. But I'll tell you why. It's because so-and-so has a disability. Publix isn't allowed to say that. I am. As an uninterested party, I'm not affiliated with Publix in any way. I'm a lawyer, and I know that's the reason why. So anyway, that's the best way to deal with that particularly tricky situation. Now let's talk about the service animals, the comfort animals. I don't want to embarrass anybody by asking, has anybody fielded that request? But I've had it multiple times within the last 2 weeks from different clients in different industries. There was actually just a case that came out where the EEOC sued a long-haul trucking company for not permitting one of its long-haul truckers to allow to take his comfort animal with him on cross-country trips. And the EEOC ended up settling on terms where the employer agreed to provide that particular accommodation. The danger is out there that the EEOC could decide that your denial of a request to use a service animal amounts to unlawful discrimination. Excuse me. You may hear buzzwords such as comfort animal or service animal in the request. What do you have the right to ask for? Do you have the right to ask for a prescription from a doctor showing that so-and-so needs a service animal? No. You may have heard of service animals in workplaces being very limited, that only dogs and small horses are permitted to act as service animals. So when somebody wants to bring their comfort python into the workplace, you can say no. The answer is, believe it or not, you might have to let the comfort python into the workplace. The small horses and the dogs has to do with Title III to the ADA, which pertains to public accommodation. So if you operate a hotel or a restaurant and a customer comes in with the comfort python, your answer can be, no. If they come in with the dog or the small horse and they say, this is a service animal, it detects when I'm about to have an epileptic seizure, I need to have it with me at all times so it can alert the public so they can call the authorities, 911 or whatever, yeah, you got to let them come on into the restaurants. Those are the rules that apply to public accommodations. With respect to employment, though, we're still in the wild, wild west. It is not as heavily regulated as Title III when it comes to service animals or comfort animals. By the way, public accommodations, places of public accommodation, do not have to allow you to bring in comfort animals, animals who are just to make me feel good about myself, the mini chihuahua and whatnot, etc. The animal must serve some purpose, and you have the right to ask, what is the service the animal performs? But that's about it. Again, that's for public accommodations, places of public accommodations. When it comes to employment law, we're back to the same old reasonable accommodation, exception to our policies. We have a no pets in the workplace policy. Do we have to make an exception? And the answer is, we might. If it's not an undue hardship on us and it's an accommodation that enables the employee to perform the essential functions of the job, we might have to allow it. Be mindful, of course, that having the dog there must be to enable the person to perform the essential functions of the job. You have the right to ask, what essential function does this animal assist you in performing? You also have the right to ask, is there any other accommodation that could be provided other than bringing the animal into the workplace that will enable you to perform the essential functions of the job? Likewise, it is A-OK to ask for medical documentation verifying the employee needs to have this animal in the workplace. With the long-haul truckers, the truck driver did actually have a doctor's note saying so-and-so, is isolated in his job and needs to have an animal with him for comfort. And eventually the EEOC said, yeah, we think that that's a reasonable accommodation. It is not, however, okay to demand any particular sort of certification of a service or a comfort animal. And there are companies out there that will provide these certifications saying, Junior the dog has passed our extensive 8-week training course and is certified as a service animal under, the Keith Hammond Service Animal Society of America. It's pretty easy to get those. You can't require them, though. All that the employee needs to show you is some sort of medical documentation. Doesn't have to be in a specific form that the employee needs this as an accommodation. And likewise, remember what I said before. It's not okay to disclose to coworkers that an employee has a disability. So when a coworker complains, why does so-and-so get to bring in Fifi the dog and I can't bring in my pet iguana? You're somewhat limited in what you can tell them. You can't say it's because so-and-so has a disability. But what you can say is, hey, I think it's time that we do a little disability sensitivity training in the workplace here so that all of our employees know what others might have the right to do. Frequent issue. Somebody wants to bring their dog into the workplace. The coworker in the next cubicle says, I have allergies. Is that enough for you to deny the accommodation? I won't even ask for a quick show of hands, yes or no, because you all know by this point, if I'm asking the question, there's more to the story. There is an organization called the Job Accommodation Network, loosely affiliated with the EEOC. It's not an official office of the EEOC, but they do work somewhat hand in hand. If you need to get on their website is www.askjan, Job Accommodation Network, not Jan, the middle child in the Brady Bunch, askjan.org. There will be a tab specific to service animals and comfort animals in the workplace. That tab also provides 14 questions you need to go through to determine who wins in this case, employee with the animal or employee with the allergies. And here they are. I'll go through these quickly. What you should consider is, could you allow the employees to work in different areas of the building? Could you establish different paths of travel for each employee? Could you provide one of the employees with private or enclosed workspace? Could you use a portable air purifier at each workstation? Could you allow flexible scheduling so that the employees don't work at the same time? Could you allow one of the employees to work at home or move to another location? Could you develop a plan between the employees so they're not using common areas at the same time? Could you allow the employees to take periodic rest breaks, such as to take medication if you're the one with the allergies? By the way, when I went through this 14-prong question with an employer the other day, we actually brought in the employee with the allergies to say, well, could you just take breaks and take allergy pills? And the reaction we got was like, you have got to be kidding me that you're asking me this question. You should also ask the employee who uses the service animal if he or she is temporarily able to use other accommodations to replace the functions performed by the animal. You should explore whether you can arrange for alternatives to in-person communication, such as email, telephone, teleconferencing, and video conferencing. You should ask the employee who uses the service animal if she's willing to use dander care products on the animal regularly, and whether, of course, that would actually be an effective way to avoid the allergies. You should ask the employee who's allergic to the service animal if he or she wants to and would benefit from wearing an allergen or nuisance mask. Another question you might be surprised to learn the employee said, You must consider adding HEPA filters to the existing ventilation system. And finally, you should consider having the work area, including carpets, cubicle walls, and window treatments, dusted, cleaned, and vacuumed regularly. I see looks of bewilderment on the faces of many out there. That's what I am here for. to scare everybody into knowing what is expected of you when somebody wants to bring the animal in. Yes, we have a question.
So do they have to let you know that they need a service animal, or what if they didn't let you know when they accepted a job and it becomes the reality?
So there's two questions really. One is, do they have to let you know they need a service animal? And number two is, what if they didn't tell you like during the interview process? Let me start with the second question first. They don't have to tell you. What you can ask is, do you require an accommodation to perform the essential functions of this job? You know, and that at least opens the door so you might learn ahead of time that they need the service animal. Do they need to let you know? Let me switch up that question a little bit. The answer that I'll give, which isn't directly answering the question, but that's what we lawyers do, is that an employee needs to make the request for an accommodation. Or once the need for an accommodation becomes known, the employer has to interact or engage in the interactive process with them. So can the employee just show up on day one with the service animal? The answer to that is, if they do, tell them, whoa, hang on, do you need to have a service animal as an accommodation to a disability? If the answer is yes, then we go into all the questions that you would normally ask. Well, what's the nature and severity of the medical condition? Why is it necessary for the service animal to perform the essential functions of the job? Is there another accommodation that we could make? Meanwhile, the coworker comes in the door kicking and screaming, hey, I have allergies, we can't have the service animal in here, and now you got to go through the 14 questions and whatnot. You're probably safe telling the employee to send the service animal home at least for as long as it takes you to evaluate the requested accommodation, right? And then get back to them as quickly as you can to either say, yes, that's permitted, or no, here's specifically why it would be an undue hardship for us to make this exception to our no animals in the workplace policy.
Yeah, could we just start, instead of giving them the answer, do you need this dog to accommodate a disability? Could we just say we don't allow dogs in the workplace and see if they tell us if they have a disability?
So that might be one way of doing it, but I think, let's not beat around the bush on this one. If they show up with the dog and you say, hey, listen, we have a no dogs in the workplace policy. Do you need an accommodation to perform the essential functions? Is the dog necessary as an accommodation to a disability? That gets the conversation going, and you're meeting your obligations to engage in the interactive process with them. And if they say, well, I've never been diagnosed, but the dog makes me feel better, the answer is, I'm sorry, we can't accommodate that if it's not for some sort of disability. You could certainly invite them to submit whatever paperwork they would like to justify their need to have the service animal there to accommodate a disability, whether it's mental or physical. But I will say that is a very, very tricky issue to deal with, and one that has the EEOC's sympathy. We've seen that they are very willing to bring private lawsuits against employers when they think a comfort animal or a service animal should have been allowed in the workplace. I mentioned this earlier. I'm not going to go into this too much because the law has not changed since the Affordable Health Care Act. This is what amended the Fair Labor Standards Act to allow the breaks to express breast milk. You, of course, cannot put them in a bathroom somewhere to do that. You have to have a separate room involved. There is an undue hardship component to this accommodation as well. If you have fewer than 50 employees, and you can show that there would be difficulty or expense in complying in comparison to the size of your workplace or employer as a whole, your financial resources, the nature or structure of the employer's business, you might be able to get around the requirement that you have a separate room that's not a bathroom. It won't get you beyond the requirement of permitting a new mother to take frequent breaks. You can still, of course, use your normal break policies in terms of what's paid and what's unpaid, but you still have to provide those. So before we move on from accommodations, do we have any questions? Fantastic. Now we get to the broken record component of this presentation. I mentioned that if you had been here 2 years ago, you'd hear me talk about a new proposed overtime rule. You'd hear me talk about opinion letters that the Department of Labor issued, and you'd hear me talk about EEO-1 reports having to include certain pay data. Well, right after we gave that presentation, the courts stepped in and said, nope, no new overtime rule. You've exceeded your authority, previous administration. We're not going to do that. Nope, no new EEO-1 rule. It wasn't a court that said that, though. Rather, what happened with the new EEO-1 rule, which we'll go over in more detail in a minute, was that after Trump was inaugurated, he had the Office of Management and Budget, which had previously approved the rule pertaining to the EEO-1 report, say, listen, we're not going to implement that after all. As it turns out, a court just said, no, you're not allowed to do that. So we're back on the clock with the EEO-1 report. But first, let me go over the new proposed overtime rule. You may or may not have heard that under the Trump administration, there is now a proposed rule that's out there for public comment that will probably become final around-ish January 1, 2020, that increases the minimum threshold for salaried exempt employees from what it is currently $23,660 a year up to $35,308 a year, which works out to $679 a week. You may recall 2 years ago I was telling you, hey, the minimum salary level is about to go up to $47,476, right? What most people did at that point was they either increased the salary of people who fell below that threshold up to the 47 and then didn't change it back once the court, the day before this rule was to go in place, blocked it. So you still have those employees sitting there at 47,000. Or they converted employees who fell below the threshold to hourly non-exempt employees and never converted them back. So the good news, to the extent that there is any, is that many employers have already addressed this situation. The universe of your workforce that you want to look at would be employees earning a salary of less than $35,000 a year who you are currently treating as exempt. Those are the people that you may need to make an adjustment on before, I say January 1st, but that's really just speculation as to when the rule will go into effect. I think that the comment period closes sometime in May or June. So we could see a rule as soon as that even. But even under the previous rule change, there was somewhat of a grace period to allow employers to come into compliance. They didn't enact the increase right away. There was a several-month heads-up period. The other thing about the new overtime rule that might sound familiar is that non-discretionary bonuses and incentive payments, such as commissions, might satisfy up to 10% of the salary requirement. So in other words, you could pay your employees about $32,500 or $32,700, whatever it comes out to, so long as they made enough in non-discretionary bonuses or commissions to fill that gap up to the $35,308. Now, the downside, if you choose to do that, by the way, is if the employee ends up not earning the commission or not earning the non-discretionary bonus, you got to bump them up to $35,308. So is there really too much benefit in structuring your compensation package that way? Probably not, as it turns out. If you have any what they call highly compensated employees, and I use that in the legal sense, not the sense of, yeah, this person makes a ton of money, but rather you're hanging your hat on the highly compensated employee exemption, which currently is available to employees who earn at least $100,000 a year, but who don't satisfy the duties requirement of the white-collar exemptions like executive, administrative, or professional. They only have to meet one of the elements of the duties test of any of those exemptions that I just mentioned. Be mindful that the minimum compensation is about to skyrocket from $100,000 a year to $147,414 a year. Notably, this is even higher than what was proposed by the previous administration in terms of what increase to the highly compensated employee compensation would be. Under the previous proposal, it was up to $134,004. Don't forget that last $4. We don't want anybody to be non-exempt because they're $4 short. This is significantly more. There will not be automatic increases every 3 years, as had been previously proposed. Rather, right now, the rule is that there's kind of this aspirational goal of increasing the minimum compensation rate, not only for highly compensated, but also for the 35,000 folks, every 4 years, and opening it up to public comment each time every 4 years, rather than tying it to a cost of living or the consumer price index, which is what the previous proposal was. There is no change, by the way, to any of the duties tests. So, if you're an exempt executive, you have to have a primary duty of managing the enterprise or a customarily recognized subdivision thereof. You have to manage at least 2 full-time employees or their equivalent. You have to do things like hire, fire, or have the power to hire and fire. I'm not going to get into all of the duties. Those are all the same. Those are not changing at all. If you have an employee who currently does not meet the duties test, they're not going to be magically exempt because you pay them $35,308 a year. You need to make sure that they meet the duties test. Yes?
Does the highly compensated, can some of that come same 10% as?
Yeah, as a matter of fact, with the highly compensated, and we do need to see what the final rule ends up looking like, but as of right now, they still have to be paid in part with a salary, but the salary component of that 147 only needs to meet the 679 a week. You know, so if they're partially salaried but mostly commissioned and they make that 147, and of course be mindful they still need to meet at least one duty of those white collar exemptions, then they might meet the highly compensated test.
So, and I guess my question is because of the inside versus outside sales difference? So
Yeah. Inside versus outside sales. What I would caution you on there, by the way, the question had to do with can the highly compensated employee's compensation come from something other than the salary? And this comes into play when you have inside salespeople such as timeshare salespeople, call center people who make a heck of a lot of money, but they don't meet the duties of an outside salesperson. Because they work inside. They don't regularly go away from their normal place of business, which could be a home office, for the purpose of making sales or obtaining contracts. This increase probably won't make much of a difference as to whether somebody qualifies for an exemption if they're already an inside salesperson. If they're already inside sales, they're probably not exempt. There's a limited instance where they would be if they fall into the 7I category, which has to do with mostly commissioned employees. We can talk about that offline. But be cautious. If you have an inside salesperson, even when they're making a ton of money, they still probably don't fall within the highly compensated employee exemption. And trust me, I don't know if anybody here is in timeshare, but timeshare salespeople can earn $250,000, $300,000 a year in straight time. And every time it's 7 o'clock and they pick up the phone to check in on the customer they sold the timeshare to last week, that's on the clock. So when they work more than 40 hours a week, their regular rate can be enormous that they are entitled to time and a half on. So anyway, now that I've scared everybody out of getting into the timeshare business. Did you have a follow-up question? Maybe? We'll talk later. Here's where the public comment period expires. It's May 21st. We expect probably January 2020 is when we can expect we need to have the new salary level in place. Additionally, I just wanted to highlight this for anybody here who might be interested, who might have a need for utilizing this service of the Department of Labor. Back in the day, prior to the Obama administration, the Department of Labor would issue what they call opinion letters at the request of employers to address a specific situation. For example, I once requested an opinion letter on on behalf of, I should say, a large hospital system which employed security guards in the workplace. The security guards took 30-minute meal periods. They had to wear radios around their neck. And if there was a call on the radio that they had to respond to, they were expected to respond. If that call interrupted their meal period, they would not be charged with the meal period. All that time would be considered hours worked. And the security guards were complaining that the mere fact they have to carry the radio and listen to it makes their meal periods compensable, that they're doing work. Well, I can tell you that's a pretty gray area in the law. It's not crystal clear whether or not the employer is justified in deducting that time or whether it must pay the employee. So we wrote to the Department of Labor, setting forth the situation, asking them for opinion. We had to certify there's not currently litigation. We're not asking you this so we can run into court with this and say, look, Judge, you ought to side with the Department of Labor's position on this. And assuming all those things are true, the Department of Labor would provide employers with official opinions. What's the benefit of that? Well, if you ever get sued for something that the Department of Labor told you was okay, that's a defense, at least a defense to certain types of damages that the employee could recover if they went to court. It was a great thing. They went away, though. Under the Obama administration, the rationale being, look, We, the Department of Labor, have limited resources. We're going to focus our resources on enforcement out in the field rather than paying lawyers in an office in Washington, D.C. to draft these opinion letters. So great for employees, not so great for employers. Under the Trump administration, the department has gone back to issuing these opinion letters. So now you can go ahead and, if you have some wacky situation, either you or your lawyer can write to the department and ask for an official opinion. Now, by the way, it did take 5.5 years for us to get a response from the Department of Labor. It's not as though this is an instantaneous process, and it very well could be that by the time the DOL gets around to responding, we have a new administration in town that's not going to issue these opinion letters anymore. But I at least wish to make everybody aware that this is out there. It does happen from time to time. If you have the need for an official opinion in a very gray area of the law, talk to me and we can consider it. Now for the scariest portion of today's presentation. On the middle of your table is a 3-page handout with the words sample in large block letters. What is this document? Do we have a question over there before I proceed? Question anywhere? Okay. What is this document? This is the addition to the EEO-1 report that covered employers will have to complete that provides pay data, as you can see, for various categories of employees: male, female, white, black or African American, Native Hawaiian or Pacific Islander, Asian, Native American, 2 or more. And then the column, or the rows I should say, but the column on the far left of this sheet has various job categories such as executive or senior level officers and managers, first or mid-level officers and managers, and go all the way to the end. We've got service workers, laborers and helpers, and everything you can think of in between. I have a question already.
Spared everyone that has less than 100 employees.
Well, that is my next point, is you've seen this report, and I said covered employers. When do you have to file an EEO-1 report? The way that I always think of it is think of the rule of 100. If you have 100 employees, you need to submit an EEO-1 report to the Equal Employment Opportunity Commission. The other 100 is 50 plus 50. If you have 50 employees, but you're also a federal contractor or a subcontractor of a federal contractor, and you work on contracts valued in the aggregate at $50,000 or more, you have to provide an EEO-1 report. So 50 plus 50 is 50 employees plus 50,000 in federal contracts as a prime or second level contractor with the federal government. If by chance you are a mere 15 employee outfit covered by Title VII but not covered by the EEO-1 report, now is a great time to go get coffee to celebrate privately away from the folks who are covered by the EEO-1 reporting requirement, etc. So assuming that everybody here either is or may in the future be working at an employer where you've got to fill these reports out, this is what it's going to look like. How did we get to where we are? I alluded to it earlier. The legality of how we got here is less important than the fact that we're here now. There was a lawsuit brought by some advocacy groups that demanded that the Office of Management and Budget does not have the authority to go back on its word and say, yeah, we approved this under the Obama administration, but now we think that, this is just going to cause a lot of paperwork, and there's a law called the Paperwork Reduction Act, and so we're just not going to comply with the law that the past administration passed. Last month, the federal court that was addressing this case ruled in favor of those advocacy groups and said, you don't have the authority, Trump administration, to go back on this law that was passed lawfully and which the Office of Management and Budget previously approved. The pay data component of the EEO-1 report, which is this, should be immediately reinstated. Well, how immediate is immediate? The current deadline for EEO-1 reports, or the next deadline, I should say, is May 31st of this year. In that court case, the Office of Management and Budget and the EEOC itself have filed briefs saying, we don't have the capacity to take in this data as early as May 31st, 2019. The advocacy groups Monday filed a brief, or it might have been Friday, saying, too bad, so sad. Judge, you said immediately reinstate. Employers need to provide this information on May 31st. So where does that leave us? Well, we're in somewhat of a gray area until the court actually comes out with a ruling on this. My own suspicion is that the court will have some sympathy for not only the EEOC, but also for all the employers who are affected by this, who now would have only, a month and a half to compile all of this data. I mean, you may have the capacity to do this relatively easily, but it's still a whole heck of a lot of information to compile. As a matter of fact, way back during the earlier administration, when they were passing the new EEO1 pay data report, I saw an estimate out there that your run-of-the-mill employer covered by the EEO1 reporting requirements would spend upward to 68 person hours per year complying with the new pay data requirements. Now, honestly, that sounds pretty high to me, but remember, not every employer is as sophisticated as being able to, number one, compile this data in the first place, so all you have to do is insert a pivot table on an Excel spreadsheet. So anyway, that's where we're at. My recommendation, monitor closely. Feel free to check in with Myra. Feel free to check in with me between now and May 31st. If I hear anything about it, I'll probably send out an email blast. So if you're on my list of getting email blasts from me, you'll likely see it. At a minimum, Myra will see it, and she'll send it out to you as well. If we have to comply with this by May 31st, we'll let you know. Yes?
What if you have two companies with two different tax items?
Ah!
What are they equal to?
The EEOC's position is that if you have a common enterprise, even though you have separate corporations that make up that enterprise, and the enterprise is covered, you need to submit the EEO1 data on behalf of the enterprise. But that's an excellent question. For the recording, the question was, what if you have multiple companies, multiple tax ID numbers, none of which would by themselves have to report on an EEO1, but together you meet the requirements? The answer is you look at the combined total there. All right, now it's time. Protected concerted activities. The National Labor Relations Act is a law that is meant to provide employees the right to join or form unions, and it also gives non-unionized employees the ability to engage in what they call protected concerted activities. Those would be activities that are made on behalf of more than just one employee, designed to protect their rights or which address the terms and conditions of their employment. I will give you an example of this. Talking to your coworkers about your compensation is a protected concerted activity. You cannot have a policy in your handbook that prohibits employees from discussing their compensation with each other. That is usually what I look for very first when I'm reviewing a handbook to determine how much time it's going to take to revise a handbook. Because I'll tell you, if they have a policy in there that says don't talk to your coworkers about pay, there's a whole lot more in there that they probably have that's unlawful as well. The Obama-era National Labor Relations Board issued a number of cases during an 8-year period which reversed or significantly amended existing labor law, making very common handbook policies unlawful under the theory that those policies might chill an employee from engaging in protected concerted activities, such as talking about compensation, but also talking to the media or a union or others about how lousy so-and-so is as a manager with the hope of fomenting further action by their coworkers. When Trump first became inaugurated, the shift in the NLRB went from having 3 Democrats on the 5-member board to having 3 Republicans on the 5-member board. The board has been very open about the fact that their goal during the Trump administration is to roll back some of the Obama-era rulings. They began to do so in December of 2017, so we're talking a year and a half ago, in a case involving the Boeing company and some of its handbook policies. The punchline to all of this, because if you were here last year, I went over the Boeing case. The Boeing case laid the groundwork for the NLRB's goal over the next few years of being able to reverse these. The Boeing case came out and said, we're not going to find handbook policies illegal just because there's some remote possibility that in some way the policy itself would chill protected concerted activity. Some examples of what previously would be unlawful that now is perfectly lawful would be rules such as having a no photography rule in the workplace. That was the specific one that was in Boeing. Boeing, of course, manufactures military airplanes. You know, there are spies who try to infiltrate Boeing so that they can sell secrets to Other state entities, meaning countries abroad that might not have interests aligned with the United States, they have a compelling reason to disallow or prohibit cameras in the workplace. Initially, though, the NLRB found, no, you might be chilling employees from taking pictures of dangerous work conditions there. Got to allow the spies. Let the photos in the workplace. Finally, when the case got up to the board level itself, initially it's with an administrative law judge, the board, the 3-member Republican-controlled board said, enough is enough with this nonsense about chilling employees or having some remote interest. This no photography rule by Boeing has a completely legitimate interest that far outweighs whatever Section 7 protected concerted activity right the employees might have. Some other examples that the Boeing case gave to us of the types of rules that previously the board had major problems with, but now which are back to being okay, would be things like civility rules in the workplace. Previous NLRB within the last couple of years says you can't have civility rules that require employees to be harmonious with each other. There could be conflicts in the workplace over how people feel about whether to join a union or other labor-related matters. So you cannot prohibit employees from having those heated discussions. Well, now we're back to you got to treat each other respectfully in the workplace. Also, rules against insubordination. There was a fine line as to what you could permissibly put in a handbook about refusing a directive from a supervisor. We're relatively clear on those now. Disruptive behavior rules, rules protecting confidential or proprietary information. I'm not going to go through all of these, but be mindful, this is a pretty significant chunk of handbook policies that 2 years ago, 3 years ago, 5 years ago, we were making extensive revisions on to comply with board precedent. We're now back to where we were beforehand. So if you remember making those widespread revisions to your handbook, now's the time where we might be able to go back and put some of those old policies in. Now, that's not to say that every policy that you had to take out is suddenly okay. There is a middle ground. These are the policies where you probably want to talk to a labor lawyer about before you go back to what your old policy was. Conflict of interest rules. The problem there was most conflict of interest rules, if you read them literally, say you can't have another job that might be adverse to the interests of the employer. Well, the problem is that would exclude you from going to work for a union who might be wanting to unionize the employer, which you have a right to do if you're a sub-supervisory level employee under the National Labor Relations Act. So it's possible you could come up with a viable conflict of interest rule now, but be careful how you draft it, that you don't overstep what you're permitted to do. The same is true with the rest of these policies listed back here. And then there is, at the other end of the spectrum, rules that are still unlawful under the National Labor Relations Act because they expressly infringe on an employee's right to engage in these protected concerted activities. For example, you still cannot have a policy that says don't talk to your coworkers about your pay, that's your business, not theirs. Still unacceptable. The Boeing case also cautioned that, hey, even though now we'll give you more leeway on what your policies say, in other words, we're not going to determine that you violated the law merely by having a handbook policy. Be mindful that you might still implement them in such a way that violates the National Labor Relations Act, so you're still prohibited from enforcing a policy in such a way that you're punishing employees from engaging in protected concerted activities. Now, here's what's a little bit surprising, and the reason that I brought this up. Keith, this is a year and a half old. Why are you telling this to us now? Is because since that time, there really haven't been too many cases where the NLRB has affirmatively gone back and changed a previous rule. The Boeing case set the stage for it, but then the stage was dark for a year and a half. Just within the last couple of months, we're now starting to see the wave of cases coming out that are overturning previous policies. Cott Beverages is one that they actually have a plant here in Florida. They had a no cell phone in the workplace policy. They were sued at the time the Obama administration, NLRB, was still together. And at the time, they lost, of course, because that administration's position was you cannot ban cell phones in the workplace. Employees have the right to record dangerous working conditions. Now the NLRB has said, well, there's been a change since then. You know, they cited the Boeing case. They've overturned things. My prediction is we're going to start seeing an avalanche now of handbook policies that we had to change 2 years ago, 5 years ago, that now are going to be okay again. I'll very briefly tell you the NLRB is also changing its position on what constitutes a joint employer. If you use staffing company employees, for example, and you sign an agreement where the staffing company says, hey, we agree that we assume all liability, you're not really the employer, we are, those agreements mean absolutely nothing in the eyes of the NLRB. If you direct the employee's work, you're going to be a joint employer. The NLRB a few years ago, though, went one step further and said, if you even have the ability to affect terms and conditions of employment, even if you don't exercise it, but if you have the ability for one of your supervisors to tell that staffing company employee, hey, sweep up the floor, that makes you a joint employer. Now the board is going back to the old days again, where only if you actually exercise the authority or the ability to affect terms and conditions would you be considered a joint employer. This issue became rather famous because of a McDonald's franchise, I believe, up in Illinois. McDonald's Corporation really had nothing to do with it other than collecting their royalties for the use of the Golden Arches. But there were all sorts of violations going on at that particular restaurant. Bad franchisee. But the employee was permitted to sue both the franchisee, the individual who owned that franchise, as well as McDonald's Corp. And McDonald's Corp is like, wait a second, we had nothing to do with any of this, but they were still dragged into the case. That's on its way out now. Independent contractors is another area where the board is shifting. This is a very lengthy discussion that I would want to have with anybody considering classifying a worker as an independent contractor. Just be mindful there's been a shift in the law, at least in terms of with the NLRB on what constitutes an independent contractor. Basically now we focus on whether there's an entrepreneurial opportunity for the employee to make a profit or a loss doing whatever it is they're doing. As opposed to, are they treated just like an hourly employee or a consultant and you're paying them X number of dollars per hour? And some consultants could be independent contractors, but just be mindful that's what's going on out there right now. In the courts, this likely is not going to be news for anybody. The way the U.S. Supreme Court operates is that in the fall, they hear oral arguments on cases through January, even February. January, February, March, they decide what cases they'll hear next year. And then maybe as early as late April and all the way through June, that's when they issue their opinions. So the last meaningful employment law-related opinions came out last June. You've likely at least heard of them in the news. If not, I'll share with you what the rulings were. The first was a case called Epic Systems. It dealt with whether or not you as an employer could require your employees to sign a class action waiver and arbitration agreement in the employment law context. And the court said, yes, you can. That's not a violation of their right to engage in protected concerted activities. They said it, not me. The theory that the employees brought was that, hey, we have the right to join together to bring a class action or a collective action against an employer, and employers cannot take that away by making us sign off on these arbitration agreements that waive class action litigation. The court came out and said, oh, yes, they can. There's a law called the Federal Arbitration Act that was around before the NLRA. That trumps your Section 7 rights. Employers, you're free to require employees to sign off on those. The Masterpiece Cake Shop case, this was the religious versus LGBTQ rights case, which everybody expected. The court is going to tell us finally who yields to who here. Would it be the rights of this group or the rights of that group? The answer is we still don't really know. The bake shop who refused to bake the cake for the gay couple ended up winning at the Supreme Court level, but not because the court said these rights trump those rights. It was because the Colorado Civil Rights Commission, which was the agency that investigated, was so biased against the cake shop that the Supreme Court said the cake shop didn't get a fair shake. And it declined to address the conflict of whose rights prevail over others. So what currently is the Supreme Court considering? Well, there's a couple of cases that they might take up next year. We're not going to get a ruling this year about whether the federal prohibition on discrimination on the basis of sex includes sexual orientation or gender identity. For most of us here, that's probably not a huge issue because local laws here. Orange County, City of Orlando, they have laws that prohibit discrimination on the basis of sexual orientation or gender identity. I don't think it would be a huge change for us, but it would be a huge change for the federal law. Federal law currently does not specify whether or not sexual orientation or gender identity is discrimination on the basis of those things is prohibited. Excuse me. There's also a follow-up issue to that arbitration agreement case that I mentioned earlier. And the issue is this: what if there's an arbitration agreement, but it doesn't say anything about you waiving your right to bring a class action? Can I bring a class action in arbitration? And currently the answer is, we don't know. Some arbitrators say yes, some arbitrators say no. Supreme Court has a case in front of it that might decide it. And then the last one, I think may be the most interesting. Many states, not Florida, have enacted laws that went into effect earlier this year that say employers cannot use an applicant's past salary history as a factor in setting their current compensation. The rationale being that females have been historically discriminated against to such an extent that relying on their past salary information will result in them earning less than male employees and will perpetuate the cycle on and on and on and on. Florida's not one of those states. I think it's 15 or 20 states. It's a sizable minority that passed those laws simultaneously. But there's a case that the Supreme Court is considering whether to take up, where the issue is whether the Equal Pay Act, which makes it unlawful for employers to pay men and women different wages for the same work, permits or prohibits employers from using an applicant's past salary information to set his or her current compensation. So even in states where we don't have that specific state law, we now might have the same legal effect, the same requirements of not considering that. But again, we're probably a year and a half away from a decision in that particular case. So we have covered a lot of ground in a very short amount of time. Let me open this up to questions if anybody has any on our topics today. Yes?
So with regard to equal pay, a while ago, I pulled that up with our application, your history, because I got this information a few months back, and I said, we're revising the application. Let's pull it off just to be proactive. Plus, we, of course, being government, have a pay grade system, so we're kind of covered on that end. However, we do have a space that asks for people's salary requirement. And I'm wondering if that, what you think would fall in line with the same question as to what was your previous salary? If we're asking them to define it, are we asking, does that fall in that same category?
Yeah, it does. I think that's probably the next point of attack. I think the first factor that the advocacy groups and some employers, for that matter, want to eliminate would be the information on the past salary history. But I think once that is more or less uniform across the board, you've identified what the next pressure point will be, that people will want to be unlawful to consider, don't even ask the question. And for those who don't know, Nancy's in the public sector. We have some different considerations in the public sector as well. You mentioned them. The pay scales are set. As a private employer, you can decide what you want to pay anybody within reason, as long as you don't do it in a discriminatory fashion. But public employers play by a somewhat different set of rules anyway. I would predict that issue might come to the forefront in the public employment setting before the private employment, but I could be wrong. That's not what happened with the ban on considering past salary information. That was directed at private employers. Anybody else? Any other questions? Yes?
We have an employee who is going through transgender. And my question is, the restroom situation with applying reasonable accommodations. It hasn't come up, but there's been an issue with either the male or the female employees. But I don't know if it does become an issue, how is that handled?
Yeah, that's we should have an offline conversation on this, because that's a topic that we could talk about considerably. I can give you the highlights. The EEOC's position is, surprise, surprise, the employee gets to use the restroom of the employee's choice. Who cares what the coworkers say? And no, you can't designate a separate bathroom for that person to use. With that being said, that's the EEOC. Maybe, maybe not. That's how a court might feel about things. And likewise, it's up in the air whether under federal law, as well as, by the way, under state law, gender identity is protected. I mentioned that if you're in a jurisdiction with a local law, it is, like City of Orlando, Orange County. Think of the mostly metropolitan areas and counties in Florida. Almost all of them have those gender identity protections built in. They probably would side with the EEOC's viewpoint on things, but the question is, what if you're in a rural area in the state? What if you're out in, I don't know, Volusia County, yeah. Right. And then, other questions present themselves as well, like how large are you? How many employees do you have? Do you have separate bathrooms in the first place? Is one of your options just to make all your bathrooms unisex? So anyway, the point of this being, there are a lot of questions that we could ask. The best case scenario is nobody cares. The employee uses the bathroom of the employee's choice. Nobody mentions anything about it, and everybody's happy, but I can certainly see the potential for issues there. Any other questions? Well, hearing none, let me thank Myra for having me today, and I'll turn things back over to her to close things out.